I'm very glad that I am not on the panel or chairing this thing because I know so little about the subject. But you're going to know a lot by the end of this evening. My function tonight is only to welcome you to UCL, to thank our chairman, who has flown over from the United States, and hand over to him. He will explain what he does a bit. You'll see something to do with DVB, and he will say what all the others do. So, drinkies afterwards outside.
Thank you very much, Sir Robin. So my name is Carter Elsroth. I'm the legal director of the DVB project in Geneva. DVB sets technical standards for digital video broadcasting. And in that regard, we have an IPR policy which fosters the formation of patent pools covering our standards. But that's not the subject tonight. Rather, this conference is on whether patent law is fit for the AI age, or and to reflect the recent Supreme Court action, fit for an emotional AI age. The format today is hardly startling. Each of the speakers will give a presentation for 10 or 15 minutes. So please keep your questions until after the end of all the presentations. And then I expect we'll have around 30 minutes for your questions. I don't think Sir Robin made the traditional request to all of you to turn off your cell phones. And in addition, I call your attention to the fact that there'll be a video of this conference. For that reason, it will be recorded. So we'll keep that in mind. I will introduce the speakers in the order that they will give their presentations. Michael Pryor. He has a background in biochemical engineering. He's worked in intellectual property for over 20 years, and he is currently the head of IPO's patents policy function. He covers both international negotiations and domestic reforms on a range of topics from life sciences to artificial intelligence and advanced technology. And in previous roles, he has worked on UK copyright policy, as well as he's worked also as well on the European Commission's IP team. Noam Shemtov here on my left is Chair of Intellectual Property and Technology Law Center at the Center for Commercial Law at Queen Mary University. He has led numerous research projects and studies funded by UK research councils, as well as by industry and commercial groups. He's recognized for his contributions to innovation, and he's been named by the European Patent Office as one of its 50 leading tech voices. He holds visiting appointments at universities in Spain, France, and the Netherlands. Virginia Driver, European patent attorney at Page White Farrer. She's worked in the field of protecting innovation in computer-related systems for over 30 years. Her practice is increasingly focused on software patents, and over the past decade, she has built a specialist team within her firm for patenting innovations in the field of AI and data science. She is the co-author of the chapter on patentability of AI in the Sweet and Maxwell publication, The Law of AI, which has been recently revised and now available in a revised edition. We'll come back to that point in a moment. Matt Hervey is head of legal and policy at Human Native. He's recently moved there. It's a new AI startup in London that's building an AI data marketplace, bringing together rights holders and AI developers. Previously, he was for 16 years at Gowling, where he was a partner in the intellectual property team and headed its AI law team. He is the general editor of the Law of Artificial Intelligence, the Sweet and Maxwell, revised edition now available.
Can I interject? Matty Labour, my joint general editor, is in the audience.
Okay. he's been made a Fellow of the Royal Society of Arts for his work on AI and the law. He helped found this year the International Law Association for Artificial Intelligence. He's a particular expert on AI and IP, including the subsistence and ownership of IP and inventions, and also in text and data mining exceptions, and the cross-border use of data and training models. So in this for our conference this evening, there are three things going for us. We have an excellent panel. Second, the application of IP law to AI is a very compelling question. And third, the Supreme Court had the kindness to make our topic very timely tonight. So we expect to hear, I guess, a lot about the recent Supreme Court action. So I have no further introductory comments. I ask Mike Pryor, please, to give his presentation.
Okay, good evening, everybody, and thank you to Professor Sir Robin, Carter, Lynn, and UCL for inviting me here today. For a bit of a context, I'm a civil servant at the UK Intellectual Property Office and in a policy role. And for those of you wondering what a policy role might entail, it involves helping deliver legislation, participating in international negotiations, communicating the government's policy intent, why I'm here today, but principally providing advice to ministers. And over the past 5 years, my team has been behind providing advice to ministers on AI and patents policy, and is responsible for some of the consultations and call for views that have come out of government in that period. So I wanted to highlight a little bit of history for you today in terms of those consultations, the questions they asked and the conclusions they reached. And also, hopefully, some of that will, I'll go on to highlight some of the questions put forward by Lord Justice Arnold at the QM IPR conference, as those are exactly those that preoccupy myself and team at the moment. And I'm very particularly interested to hear what my fellow panel members have to say on some of this, because it's so germane to what we're doing, so no pressure. This is the clicker. Oh. Perfect. So a little background about the interest of the current government in AI and IP. Current Minister with responsibility for both AI and IP policy, sitting within the Department for Science, Innovation and Technology, is Burial Clark, Parliamentary Under-Secretary of State for AI and Digital Government. And having a single minister with responsibility for AI and IP is the most obvious sign of the importance government attaches to it, but also highlights the connection between the two. And even if much of that connection is currently manifesting itself most politically on the copyright side, there's also the patent side to consider as well. So the current government hasn't said much publicly on AI and the UK patent system, but does recognise AI as a key opportunity for shaping the development of shaping the development of the UK's economic future within its industrial strategy white paper. So moving on, with that background set, I just wanted to recall some of the recent timeline of events. Now, I'll start with Davos, but I think you're all probably very aware of that. But in some ways, that marks the start of an intense interest in the way AI and the patent system interact, and for patents at least, provided a key catalyst for some of our public consultations. So concurrent to the Davos case working its way through the courts, the IPO, on behalf of government, published a call for views on AI and IP in September of 2020, and then followed that up with a government response. And I'll come on to talk about some of the outcomes of that government response in 2021. And that call for views asked questions about, some very broad questions about the aims of the patent system, AI as an inventor, and the conditions for granting a patent infringement. So yeah, some very broad questions in that one. And then that led to a much more specific UK IPO on behalf of government consultation in October of 2021. And that asks targeted questions about expanding the concept of inventor to include humans responsible for an AI system, allowing patent applicants to identify an AI system as an inventor, providing new sui generis rights for AI-devised inventions, and of course making no legal change. So there's a range of questions, range of options for legislation considered there. And again, a government response was published subsequent to that. So I'll pick up on those government responses. Firstly, the call for views. So, I mean, essentially this kicked off, as the first point, it manifested in the consultation that followed. Secondly, the IPO published some enhanced guidelines on patent exclusion practice for AI inventions. These didn't massively change what we believe is and isn't patentable, but were taken down post the ruling in the emotional perception case at the Patent Court. We do, subsequent to the Court of Appeal decision, hope to put these back up, and of course they might change again post the Supreme Court decision. Thirdly, we commissioned an economic study to enhance our understanding of the role the IP framework plays in incentivising investment in AI. The idea was this would contribute to the evidence base government has for making policy changes. A key conclusion from that study was that the UK IP framework is not a fundamental consideration for investment by firms. So that was the finding of that study, at least by the participants in the study. So that was the opinion of the participants that took part. And then finally, government committed to working with stakeholders and international partners to establish the feasibility and benefits of a data deposit system for AI for the data used to train AI systems. In short, this didn't work. The costs and impracticality of a storage facility to hold huge data sets, if an AI system is trained on all of the internet, just meant that it was not a goer. So that one was ruled out. So moving to the last four bullets, which are the points following from the government's consultation, the government decided not to make a immediate change to UK legislation on inventorship to protect AI-assisted inventions on the basis that most respondents to our consultation thought that the current situation was enough. Now, this is all pre-ChatGPT-4 and the kind of increased intensity of interest around AI and IP, and the conclusion we reached was that we wouldn't change domestic law, but would look to finding an internationally harmonised approach to the inventorship question. And that was, I think, primarily because of the risk to global filing strategies if you had different countries making unilateral changes to their inventorship rules. The next point was looking to advance discussions in international fora on this inventorship question. And behind the scenes, UK government has been looking to use its influence to try to pursue that cross-regionally. There is cross-regional interest, but I would say that progress is very slow and difficult work, as often is with international negotiations. Primarily, I think, because countries are not entirely sure what's in their best interests economically for a harmonised approach to inventorship. Thirdly, and I've highlighted that in the third point, that part of what the UK would seek in those international harmonisation discussions would be informed by what is best for UK competitive advantage. The consultation was perhaps saying the quiet part out loud there in international negotiation terms, but that was where the consultation response ended up. And then finally, and again, this is an active area of active monitoring to actively monitor technological developments. And like I say, we've seen ChatGPT-4 appear since this consultation was published. So that's a very whistle-stop tour of UK government actions in this area. And I just wanted to also briefly highlight that UK government doesn't exist in a vacuum. There are conversations happening at WIPO. It's hosted several conversations on IP and frontier technologies, many of which have focused on AI recently. They had their 10th event last month, I think, which focused on whether to protect AI outputs. And all of these are available online. The USPTO has also published its guidance on joint inventorship, and the German Federal Court of Justice has ruled on the Davos case. I won't go into too much more detail on those because I know I don't have too much time left. So I wanted to get on to, with all of that said, the question for the future. So in terms of what activities does patent law need to incentivize in economic terms, and this is still an open question for government, first of all. I don't have the answers to all of these. I think in economic terms, looking through the kind of market failure lens, patents exist to incentivize innovation by protecting investment in R&D that wouldn't otherwise occur. And there's a question of whether AI will reduce the R&D to a nominal or marginal cost, and therefore whether there's anything worth protecting at all. We'll see how, that's an open question about how the nature of R&D will change. And then there is a link question of whether it matters that the genesis of invention lies with machines or humans. And there's a paucity of evidence here. Personal view, I would say that provided there is investment in R&D, then the inventive output needs to be protected to prevent free riding, but perhaps others might disagree. And it doesn't matter to what degree the genesis is human or machine, but the patent system is not really set up to assess the investment in R&D. And we wonder whether inventive step might help solve that question. The concept of the person skilled in the arts within inventive step has proved very adaptable over time. So perhaps it continued to adapt to exclude situations in which the R&D investment cost is marginal. But I'll leave that as an open question. And then I've highlighted prior art flooding here, but there are practical questions here about whether AI systems can make disclosures that constitute prior art, what is sufficient disclosure, and whether there's a chance of prior art flooding whereby AI outputs create swathes of, or anticipate swathes of inventions. I don't have the answer to those. In terms of prior art flooding, I think it's probably unlikely. It's the kind of infinite number of monkeys with infinite number of typewriters question, and infinity is a pretty big number. So, yeah, we'll see. And then finally, I appreciate, and I've alluded to it already, there's an ongoing litigation here involving government. So I'm a little bit restricted in terms of what I can say around patentability, but there's a question of to what degree core AI is patentable. Now, the Supreme Court might tell us what the law is, but not what the law should be, because that's a question for government and parliament. And that links me back to the beginning, where I said that the role of IPO is to provide policy advice to ministers on what the law should be, or at least what the options are. I'll stop there and say thank you very much. I look forward to questions. And I think we're taking questions at the end.
Questions at the end of all the presentations. Yep. Thank you, Michael Pryor. Thank you. Professor Shemtov.
So, good evening, everyone, and let me start by thanking UCL and IBL specifically for organizing this fantastic event. So, Professor Matt Fisher, Sir Robin Jacob, Lisa and Lynn. It's a real pleasure, and it's a topic which is close to my heart. Now, you're going to hear about a lot of topics pertaining to AI and patent law today, so it's quite a lot to cover. I would focus on one specific topic. So when we talk about patents and AI, generally speaking, we can divide this area to two main segments. One is AI as the subject matter of protection, and the other is AI-assisted inventions, where the output can be in any field, but AI was used in the process of making the invention, or coming up with the invention. I would focus on the second one, and in particular, the question of inventorship. Now, we know that when we file a patent, we are required to designate the inventor. So every patent system that I can think of, mature patent system, has this requirement. So this is just a list of provisions from some jurisdictions where this requirement is stipulated. So we are required to designate the inventor. We also know, as we heard previously, that post Dabus, the inventor that we designate needs to be a natural person. So AI will not do, and that gives rise to the topic that I want to focus on in this short presentation. And if that is so, then there is always the risk that in AI-assisted invention, one may not do enough in order to reach the threshold in order to qualify it as an inventor. Now, to what extent this concern is actually real? What do you need to show as an inventor or as a natural person in order to be an inventor under our patent system? Now, we have two explicit statements or approaches in that respect, one from the United States and the other from Germany. So the United States, the US PTO came up with a guidance or guiding principles, a list of guiding principles on that question specifically last February. And we have the German Federal Court of Justice in the very last iteration of the Dabus litigation also making some explicit statements on that very topic. So for me and for us here in the short time that I have, it would be useful, I think, to compare and contrast these two approaches and to consider their implications, because they are different. Let me start with the United States. Now, the US PTO, in its guidelines or guidance, sought to clarify this question of inventorship by going back to a ruling by the Court of Appeal for the Federal Circuit in 1998, the Pano decision, according to which there are three factors that need to be considered. By the way, all of those older decisions, of course, have nothing to do with AI. They're about joint inventorship. So how do we allocate the status of inventor in inventorship where we have multiple inventors? And I'll come back to this point later on. So according to the Pano decision, each named inventor must contribute in some significant manner. So the key is significant contribution. And what do we need by significant contributions? You need to satisfy the three Pano factors. Contribute in a significant manner to the either conception or reduction to practice. This contribution must not be insignificant in quality when measured against the dimension of the entire invention. And you must do more than simply explain to the real inventors well-known concepts or the state of the art. Fine. So this, as I said, are the Pano factors. We are familiar with them since 1998. But the USPTO then took one step further and sought to apply the rationale of the Pano factors to an AI-assisted invention context. And this is where the Court of Appeal, when the USPTO came up with its guiding principles. Now, there are 5 guiding principles. We don't really have time to go through all of them in any details, but I will focus on specifically on 2 factors for the purpose of establishing or demonstrating the difference between the US and the German approach. So I'll jump to the third factor, where the USPTO explains that reducing an invention to practice alone is not a significant contribution, and it goes on to say that a natural person that merely recognizes and appreciates the output of an AI particularly when the properties and utility of this output are apparent, or apparent as in obvious, is not necessarily an inventor. Now, why do I focus on this? I focus on this because at the time, so I'm going back to 2018, I prepared a study or a report for the European Patent Office that dealt with the question of AI and inventorship. And one of the things that I looked at when I looked across jurisdictions, including the US, was that in order to qualify as an inventor, it was not necessary for the technological leap, for the inventive nugget to originate for an inventive effort of the inventor. So, for example, a person could stumble upon the inventive concept of an invention due to sheer dumb luck. And if that person would recognize the significance and utility of this which he or she stumbled upon, it would suffice for the purpose of inventorship. Now, at the time when I looked at it, I said, well, if I apply the same rationale, I can substitute this which I stumble upon due to sheer dumb luck with an output of an AI, and then I would say, the next step would be if I would recognize, or if a person recognizes the utility and significance of an AI output, that then such a person would count as an inventor. My conclusion at the point was that this would also apply in the US, because at the time, that's early 2018, the US appeared to follow what they called the intellectual domination test. According to that, as long as the person had an intellectual, not financial domination, not administrative domination, but intellectual domination over an inventive making process or a significant part of it, that person would amount to an inventor. That very point was actually addressed by the USPTO, and the USPTO said last February that intellectual domination alone may not be sufficient. It basically applied a decision, and a more recent decision of the Federal Circuit, the Court of Appeal for the Federal Circuit from 2018, against nothing to do with AI, has to do with the invention, if I'm not mistaken, of a harness for a dog that sustained a particular type of injury. And the question was, again, a question of joint inventorship. And in that particular case, the Court of Appeal ignored the intellectual domination test. So, what the USPTO appears to say here is as follows. With respect to the output, as long as it would be obvious to the skilled person, the utility and significance of the output is obvious to the skilled person, that person is not an inventor, or may not necessarily be an inventor, because their contribution would not be a significant contribution. It would be a routine contribution. The same applies to prompting. If you're prompting an AI in a way which is routine, you may not be considered as an inventor. So you need to do more than that. In essence, what the USPTO seems to suggest, among a number of suggestions, is that when a natural person engages with an AI in an obvious or in an apparent manner, that natural person's contribution to the invention-making process may not be significant, and therefore they may not be regarded as inventors. Now, implications. Now, there are various implications here in that respect. But for example, there may be a situation where we have worthy innovation with clear societal benefit. A natural person maintained intellectual domination over the process, but the AI generated output and the person overseeing the process recognizes and appreciates it, but this may be apparent to the skilled person, or alternatively, where the inputs and prompts that prompts the AI may be an exercise of normal skill expected from the skilled person. Under such circumstances, no inventor may be identified. And if we don't have a human inventor, we don't have a patentable invention. So it is very different from adjudicating between a number of joint inventors and deciding whether Matt should be the inventor or Noam should be the inventor, because in the end of the day, in a lot of those cases, there will be an inventor, and therefore you will have a patentable invention. One of the implications of the USPTO guiding principles is that certain type of innovation may be excluded from the patent system. Now, we exclude innovation from the patent system as a matter of patent assessment or patent evaluation, right? So we do that. But in that particular context, we do it. So when we are trying to assess whether something is obvious or apparent to the skilled person, we do it under the inventive step assessment. And my main critique is that it is in the inventive step stage where we have the relevant mechanisms and levers to filter out innovation which is not worthy of a patent grant, rather than at the inventorship stage. So let me give you an example. Let's say that you have an AI system, the output of which would be apparent to the skilled person. But this AI system is not part of the state of the art for a variety of reasons. Either the model or the data is such that the person skilled in the art don't have access and will not have access. So the quality of the engagement is obvious. But isn't that also the type of innovation that we wish to reward through the patent system? Because if we don't, remember, if the AI system is not part of the state of the art, it is not necessarily likely to be repeated by a competitor. So the inventive step type of assessment has, as I said, various mechanisms and levers that helps us to try and make sure, far from perfect, but that where the innovation ends up with a grant, the inventorship assessment is less so, is less robust for that purpose. And I think for that, and I will finish with that, and I am between the two approaches, I think the German approach is much, much more sensible. So when we look at the German approach, sorry, that's final thoughts. The latest iteration of the Dabus saga is very sensible. It means actually that if we look at it, what the German court, the Federal German Court of Justice said that what you need to show is that you influenced the AI, significantly influenced the AI system, and that's it. A human contribution must play a significant role in guiding and shaping the AI system. If you're prompting it, you guided it. It doesn't have to be. The quality of your engagement with the AI can be apparent. It doesn't need to be. It doesn't need to be non-obvious. Essentially, it is at least equal to the old intellectual domination test that we had in the United States. The German court even went further in order to clarify it and said it will always be the case that we would be able to identify a human inventor, since there is no such thing as a system that searches the technical teaching without any human preparation or influence. As long as there is human in the process, not purely in a financial or administrative capacity, you have a human inventor. And I think it is my view that this type of approach is much better fitted to the era in which we live, rather than importing various tests that were designed to adjudicate questions of joint inventorship into the AI context. And I think I just reached the limit of my time, and I shared with you my final thoughts. So thank you very much.
unlike policymakers like Mike, patent attorneys aren't given to fretting about the hypothetical. We're faced day to day in the here and now with the challenge of protecting whatever innovation is currently being developed by our inventors. And that means that we are inevitably always facing the current law. So what I'm going to talk about, going to race through the current law as it applies to AI innovation. And I'm going to look at a few specific topics, a little bit about inventive step and how that might be a bit different in the field of AI, particularly Gen AI, what the implications might be for a skilled person, and I'm going to focus on humans, Noah having dealt very well with AI systems, a little bit about sufficiency, and then for the practitioners in the room, what patent opportunities there are that sometimes get overlooked when you're trying to protect an AI innovation. So for a start, we've got a little bit of a muddle straight off the bat. So patent eligibility at the EPO, enshrined in the EPO guidelines, treats AI innovation as mathematical methods. A technical application of a mathematical method is patentable, subject to the requirements of novelty and inventive step, and a technical implementation of a mathematical method is patentable. A technical application is something that the maths is doing, embodied in a computer, it's doing something practical. And a technical implementation tends to be something that's going on inside the computer. But the EPO is looking at this from a mathematical method perspective and not from the perspective of a computer program. If you contrast patent eligibility at the UK IPO, and without getting into the ins and outs of emotional perception at this stage, the UK IPO makes a distinction between applied AI and core AI. Mike mentioned core AI earlier. So applied AI, but it is in the context of these things potentially being looked at as computer programs. Applied AI is something which carries out or controls a technical process which exists outside the computer or contributes to the solution of a technical problem lying outside the computer. Whereas core AI is something that causes a functional unit of a computer to work in a new way, in a technical sense, or creates a new physical combination of hardware within the computer. The reason I'm reading is I'm reading directly from the IPO guidelines on this, because as a practitioner, I think there's quite a broad ambit of what could be regarded as applied AI and what can be regarded as a core AI, and quite a lot of grey areas in between. If you have a technical application of a mathematical method, the matter becomes relatively straightforward. So you look at what your technical application might be, and I'm assuming here that there is sufficient knowledge as to what technical application means in this context. Both the UK IPO and the EPO have set down specific examples of things that they regard as technical, and some are up on this slide. They differ actually between the offices, but generally speaking, the offices are reasonably well aligned as to what is technical and what isn't. The novel features achieve a technical effect. You apply the problem-solution approach at the EPO. And at the UK IPO, you would be looking at the technical contribution and how the technical application in the context of applied AI gave you that technical contribution. And you can then look and assess whether or not it's obvious or not. In this context, you can use all of these technical effects that might arise when you're using the technical application in support of your arguments for inventive step. For example, improved performance, improved efficiency, improved training. Now, where the situation gets a lot more interesting is in the area of technical implementation, where you don't have a straightforward technical application. So you're looking here at AI per se and how that AI is actually being implemented. And I deliberately don't have a slide on this because it's an untested area and quite confusing, and any slides tend to become a little bit overwrought, shall we say. The point being that the European Patent Office, when it's assessing inventive step, is looking for a technical purpose. Now, if you have a technical purpose for your AI implementation, you can then start to look at these eligible effects, which are the same kind of eligible effects as you might have in the context of a technical application. But if your AI implementation does not have a technical purpose, then these effects won't help you argue for inventive step and get your patent over the line. So to patent attorneys, this becomes something of a drafting challenge rather than an absolute law challenge. Because if your inventor has come to you with an invention in an area that is not per se technical, you then need to look at how you can explain that nevertheless it has a technical purpose. So you have to look very closely at how your technical implementation is being implemented in the context of a computer. Now, if it's been implemented in the context of a known computer, you've got something of an uphill challenge, because you need to be able to benefit that your implementation is making that computer work in a better way. And more than that, that was the purpose of the implementation. So if your implementation is doing something which is non-technical, like performing a business method, then you can't use any of the effects that arise incidentally from the performance of that business method by the implementation. And there are some inventions that will get knocked out. You can't even draft around some of these challenges to present them as a technical implementation if these technical effects are by the way and not the fundamental technical purpose. So you can see why I didn't want a slide to try and show you the way through all of this. The important thing to remember is that in both jurisdictions, the UK IPO and the EPO, you've got to look at technical purpose, and the words used in the EPO guidelines is motivated by technical considerations. So moving on to the question of inventive step, and just looking at the person of ordinary skill, and Noah touched on this in a slightly different context, but one of the issues that we're facing here is, even having dealt with the issues of, do you have a technical application? Can you persuade the Patent Office that your effects arise from a technical implementation that was motivated by technical considerations? You still have to face the assessment of this hypothetical skilled person. Now, in the field of Gen AI in particular, this can become very, let's say, morphed, because you can have any number of skilled people involved in the output of a Gen AI machine. And in these bubbles, I've just put a few activities and areas that might cause the Gen AI machine to produce an output. And very often it's more than one of these, could be 3 or 4 of these. Now, an untested proposition at the moment is, if you're looking at the inventive step of an invention, how many people are you allowed to put together? Now, we know that both the EPO and the UK IPO are allowed to look at groups of people, or teams, however you want to put it, and that you can combine technologies if it's obvious to do so. The skilled person can cooperate with a skilled person from another technical team if it would be obvious, or a skilled person might have hypothetical knowledge of different technologies in his head. And I think this is an area where, which does need to be looked at in the case law, followed very closely as to how the skilled person's going to be assessed and how fair it's going to be for applicants in particular, how many skilled people are allowed to jump in on someone's invention before it becomes non-obvious. I want to talk a little bit about sufficiency, because again, it's an area quite specific that has quite specific rules and how they're applied in AI. The European Patent Office has brought some clarity to this, and I am going to quote again from the guidelines because they are instructive. The technical effect that a machine learning algorithm achieves may be readily apparent or established by explanations, mathematical proof, experimental data, or the like. While mere allegations are not enough, comprehensive proof is not required. If the technical effect is dependent on particular characteristics of the training data set used, those characteristics that are required to reproduce the technical effect must be disclosed unless a skilled person can determine them without undue burden using common general knowledge. However, in general, there is no need to disclose the full training data set. And at the UK IPO, the sufficiency question is tackled on what they say is assessed in the same way as any other invention. And they draw your attention to the relevant legal principles for sufficiency in the UK IPO. The only point I would make about that at the UK IPO is that you have to enable across the whole scope of the claim. And that says a lot about the breadth of the claim in AI-related inventions that you might want to make. But you don't need to include the full training data set in either jurisdiction. You do need to enable any new models by giving adequate teaching to the skilled person, or how existing models are applied in new use cases. And so just before I go, because I think I'm probably running up close to time, just a few things not to forget about. So data structures are patentable in both jurisdictions. For data structures, you can think about protecting the training data. Both jurisdictions say that if the underlying invention is technical, then you can protect the training of a technical invention. You can also protect at the European Patent Office so-called functional data sets that might be causing your computer enabled by your model to do something concrete and practical, as distinct from cognitive data, which is just a personal information and profiles and that kind of thing. User interfaces, features which allow you to make an input to a computer system more readily are considered adequately technical for protection. And I think this is an area which often can be overlooked in the context of AI systems. AI systems are particularly complex to interact with, and a lot of work goes into user interfaces such that a human, with our limitations, can actually get an AI machine to do something useful or understand what the AI machine has done and is doing. Physical inputs will be readily obvious to most people here. I recognise a few practitioners here. Virtual models are interesting, and I'm just going to close on this. So there is a useful piece of law at the EPO which effectively says that if you're simulating something technical, you can protect that simulation. Now, there's a lot of work going on in AI to generate virtual models of all kinds of things, where the actual application would rely on physical data and would maybe have an output that controls something concrete. But what you might want to protect is the work that goes into the simulation of that physical data and the simulation of that concrete output. And at the EPO currently, you would be able to protect those. So I think that's me done. I hope that didn't run over. I didn't actually put my timer on. But thank you very much.
Thank you, Virginia. Thank you.
Good evening, everyone. And as everyone else has already said, I definitely thank both UCL and IBL for the invitation to speak. And I think for those in the audience who are expecting more of a discussion of the emotional perception case, I better clarify. I think we're going to pick that up in panel discussion. We seem to have left it between our talks a little bit, so that'll be exciting. But we have various experts in the audience on it, so stay tuned for that. I thought I'd round off the presentations by giving a few reflections on the questions which are included in the blurb for this event. And they were originally raised by Lord Justice Arnold at the end of his keynote on AI and IP at an event earlier this year at Queen Mary. His questions were addressed to the potential changes to the law, but obviously they can also be used as a lens to consider the suitability of our current law. So taking them in turn, clicker. The first is, what activities does patent law need to incentivise, and where should the balance be struck if aiming to motivate technical innovation by applicants and to encourage public disclosure of inventions to stimulate innovation by others? Well, of course, it being Lord Justice Arnold, he's already answered that question in case law, and I've given you a quote from the Hoselock case where he identifies technical innovation, investment, disclosure, and the need to strike a balance between these artificial monopolies and these goods for the individual inventor and for society as a whole. So before turning to any of those in detail, I just want to make a general point that in my view at least, I think patent law is one, artificial, and two, it is an economic rather than a moral right at heart, and that is reflected in the limited rights, the time-bound rights, for example, of true inventors regarding their patents, certainly relative to authors under the law of copyright. So starting then with innovation, it is a trite point that machines, at least, need no incentives, but clearly the people who build machines do need to be incentivized by our laws. But that is made more complex in the last 2 years, and Virginia has alluded to this, generative AI and general purpose AI adds the complexity that these machines may be able to innovate, but also do many other things. And the question is, do we have sufficient incentives to build those machines, perhaps not to be inventive, but to have the side effect that they are then used for invention, and we continue to get innovation as a result? I then turn to the anecdotal evidence, and you can agree or disagree, give your comments and views. My view is that there is heavy investment in AI, regardless of what patent law may or may not protect. And to give you a sense of scale, OpenAI's ChatGPT model is rumored to have cost in the order of $100 million to build, and I don't think that was motivated by the availability of patent protection. So I think both for the AI itself, there's heavy investment, but also specifically companies investing in AI in order to improve R&D. And that is reflected in estimates that about 20% of all funding in AI is in the life sciences sector. Now, patent protection for AI itself may be difficult, and I think with emotional perception and in other cases, and the general approach of the UK relative to the EPO and to the US, we may argue that it's relatively hard, in fact, to get such patent protection in the UK. But I personally have not heard any sense in the market that the UK is considered a wild west for infringing AI patents which are otherwise available in other jurisdictions. And I also think that when I speak to US patent attorneys who prosecute a lot of AI-related patents, it is much more about investor relations than about the desire or expectation that these patents will in fact be enforced. Moreover, the AI community, in distinct contrast to many other commercial activities, have imbibed the spirit of sharing. And so Google, for example, essentially gave away the key ingredient of generative AI, the transformer architecture, without attempting to patent it. Moreover, the timescales of change we're seeing, the timescales of improvement, the generative AI performance changes, let's say in Midjourney in a single year, means that patent protection is simply inappropriate. It's not the right timescale. You won't receive a patent by the time your product has been overtaken by your own next generation and other competitors' products. So I actually think the real barrier to innovation is actually compute and access to training data. And if I were to change anything about UK patent policy, it would be to finally address text and data mining, which I think has had a much more profound impact on what research is done here commercially than on anything in patent law. Now let's turn next to investment. And I was interested that Michael mentioned investment specifically in R&D. And that Michael said that maybe, as a result of that, the approach to the person skilled in the art might be a mechanism to resolve that. But I'm going to make a different argument. The first is there is certainly no legal requirement for investment to be entitled to a patent. If you look at the historical notes for US patent law, it says it is immaterial whether an invention resulted from long toil, for which read investment and experimentation, or from a flash of genius. And indeed, certainly in UK litigation, the invention story of the specific inventor is considered largely irrelevant, or at best secondary.
You've got a good story, it works.
Okay, Brabantia, whatever, yes, the tippy cup. There are moments, but generally speaking, whereas in US practice, it is a matter of routine that you will actually quiz the inventor to see if there's a story there. Here, we often don't bother, frankly, in practice. So I think how an invention is made and the investment in making the invention is not really the issue for AI. The real issue is the investment needed to bring the invention to market. You have the invention, and now you need to bring it to market. And we are potentially looking at a world where you press a button and inventions just spill out. There is no R&D cost at all. The issue is, what can you bring to market? And Michael mentioned the risk of market failure. And I think the clear one to watch is small molecule pharmaceuticals, where if an AI has invented it and I cannot get patent protection, my concern is I still need to do the clinical trials. My overall cost of a clinical trial campaign to bring something to market might be $1 billion. But if it's a small molecule, it can be reverse engineered at launch. So I need some sort of monopoly. Now, in life sciences, we have data exclusivity, which may plug the gap. But interestingly, the trend is to try to cut that down, not extend it. And the question is, are there other potential sources of market failure? The only one I've come across is new alloys, which may take a lot of work to test in practice, but again, can be copied relatively easily. So, do we need some sort of investment-based protection? And the other issue with patent protection, because AI is often about software, one size does not fit all when it comes to patent protection. I think the 20-year term has always been somewhat bizarre for software, and it's clearly too short for pharmaceuticals, and that's why we have SPCs. Looking further down the line, if invention becomes fully automated or push button, business models themselves may just change. Invention and R&D become irrelevant, and the businesses that survive will be those that solve compute, logistics, manufacturing, and brand. So, finally on that point of innovation, I completely agree with the UK IPO's consultation conclusion that a national change would be pointless in any case. No one is going to give up a trade secret for protection in a single jurisdiction, particularly a jurisdiction that isn't, the size of the US or of some kind. So I absolutely think our best hope is international, but as Michael said, slow progress is being made. People don't even know what they want, let alone being able to discuss it. And certainly the WIPO's new designs treaty has taken 2 decades to negotiate. And the talk now is that the whole concept of reaching treaties, even in IP, has become so politicized that there is little hope of ever agreeing a new one, at least until there is more political change. So let's turn to public disclosure. Now, in this question, I think public disclosure is about the patent bargain. And I'm not going to talk here about the threshold for sufficiency, and Virginia very helpfully talked about sufficiency as well. But here, the real risk is if I can't get a patent, my alternative is realistically trade secrets. So we have the potential danger for the loss of this knowledge to the public if we don't liberalize the patent system. Interestingly, that has been considered a national security issue. So in 2018, the US National Security Commission on AI gave its report. Chapter 12, I believe, is on IP and AI. And they raised the concern that American companies relying on trade secrets, in fact, in practice, lost their trade secrets through state actors using industrial espionage. And it would be far better to liberalize the patent system so that you could have open enforcement as opposed to the fiction that you were keeping trade secrets as between state actors. Obviously, we need to balance this with the current culture of AI. Do we actually have a problem with disclosure? And as I've already mentioned, there is this culture of sharing knowledge in the AI domain, and indeed I think access to data is more significant an issue. Now let's turn to balancing. Now, as Lord Justice Arnold and others have said, monopolies are generally bad things. They are not in the common interest. So we really need to have proper mechanisms in place to make sure that we're striking this artificial balance in a way that is overall good for society. And he talked about the mechanisms within patent law. So novelty, inventive step, and Virginia also talked about that. And AI, in fact, I think, will reduce the number of patents, not increase them, because it will raise the threshold for inventive step, and we may have more and more use of AI for finding prior art. But I think there are other mechanisms we have to consider in the round as well. There are concerns about floods of patents, there are concerns about thickets of patents, and the concentration of invention generation in the hands of a small number of AI companies. Now, I think these concerns are somewhat misplaced. I think a flood of inventions is clearly good for the public. A flood of thickets is clearly bad, but that is where you have many spurious patents around one genuine good one. But really, as AI becomes better at inventing, people have to rely on such mechanisms less because there are more good inventions, valuable inventions, from which to profit. I would also say that the cost of prosecutions and renewals is such that no company with an invention machine could afford to prosecute all their patents and then maintain them, let alone enforce them. So I think the flood of patents is something of a myth. I also think we have compulsory licenses. If people are generating vast numbers of patents which they cannot possibly bring to market, that is what compulsory license is for. And finally, where we have a concentration of power into a small number of hands, that is what competition law is for, and I don't think we need to try to fix IP law to make it work. How am I doing for time?
I'm not quite sure.
Yeah?
Maybe a couple more minutes.
Okay, great. I'll try to take the next two quickly then. The next one is on essentially on sufficiency. Virginia has already covered sufficiency. That is a patent attorney issue. I'm really not going to try to deal with it. Noam pointed me to a recent EPO decision, which is T166921, and that really is about sufficiency where your invention is AI, not an invention by AI, and that has set the threshold pretty high. You need to disclose model structure, inputs and outputs, parameter selection, source and characteristics of data sets. So sufficiency is a real issue if your patent is for AI, not by AI. But I would say where we're talking about inventive AI creating non-AI, creating a new molecule, creating a new technical product, I don't really see the issue here. Now, the issue with machine learning, famously, is a black box. It can't explain itself. So it may not be able to tell its invention story, but that's not relevant to whether you have a patent. And secondly, machine learning may be all about correlation rather than causation. So it may come up with plausible inventions without any scientific underpinning for why it should work, but it will get it right sometimes. And when it gets it right, I agree with the quote here that it doesn't matter how it works as long as the invention does in fact work and the skilled person is able to work it. So personally, I'm less concerned by this question. And then finally, how does it fit with the existing system? And I'm going to just give a couple of points very quickly from the view of my sort of patent litigation experience. And essentially what I think will happen, as Noam has said, if you have an invention by an AI, it is not patentable in this jurisdiction. The question is, can you revoke it? And Noam's also covered threshold for human contribution, so I won't do that. So very briefly, you have rectification under section 13.3. That allows you to get a certificate after the event saying it was an AI, not a person, or at least it wasn't a person. But as far as I can tell, that gives you no rights, this certificate. It's a correction of information. It wouldn't revoke the patent in any way. The second is not a patentable invention. Now, the interesting thing here is the Supreme Court in Davis said an invention is necessarily an invention devised by a person. So if after grant I can show there was no human inventor, it was an AI invention, is it in fact now revocable under section 72 because there's no invention at all, and obviously not a patentable one. Grant to the person not entitled is a non-starter. Only the actual inventor can start it. So if the AI is the inventor, that doesn't go anywhere. Abuse of a dominant position was clearly on Lord Justice Burse's mind in the Court of Appeal. But here we look at the AstraZeneca case. And if you gain, in that case, a supplementary protection certificate or potentially a patent, by misleading a patent office, it is unenforceable because you've abused a dominant position. So arguably, if you have claimed it was by a person when it was by an inventor, it is not going to be enforceable. Finally, obviousness, again, as a litigator perspective, we are talking about horrific attempts to show what would have been obvious, because you're going to have to find out what AI was available on the market at the time, what fine-tuning the skilled person would have done, what prompts and iterations he would have done, the random seed that might have gone into the input as well, which might affect the output, what the thresholds for prolonged research, inquiry, and experiment would be in those situations, and expert evidence. In short, the sort of monumental undertaking on an experiment, which we all know judges hate. So with that, I hand the policy problems back to Michael and the topic back to the panel.
Thank you very much. Thank you. So we'll be looking for questions from both students here and also from more established lawyers. But before you do that, I want to ask the panel, members of the panel, if they have instant reactions to what they've heard from their fellow panelists. In other words, exercising a right of response.
Thank you. I thought it was particularly interesting what Matthew, you were saying about the kind of investment. And from my perspective, it was that kind of investment in R&D that was important. And you were saying that perhaps it's not necessarily that, but maybe the investment in bringing things to market. I do kind of wonder, if you go down that route, are you giving some sort of market protection that isn't really a patent, it's something else?
Yeah, and the analogy is data exclusivity, where I've paid the money to do these clinical trials and no one else can use that data. They can redo the data. It's not a monopoly, although ethically it's quite hard, I think, to justify doing more clinical trials. But yeah, it's a sort of quasi-monopoly.
Sort of sui generis protection.
Yeah. I mean, investment rights are a nightmare generally. You know, the database right has never been a great success, has it? And that's based on investment. I guess I would say to Noam, there's research scientists Adam and Eve from 2009, which picked their own hypotheses at random from academic papers and then did clinical trials. So would a human then be dominating the intellectual pursuit? Because although they built the system, its actual research interests were generated by the machine.
I mean, it's an interesting one. I would go, I think as I was indicating earlier, with a rather low threshold, as in, and I actually like the label intellectual domination. We know that financial and administrative domination or involvement was never enough, and rightly so. But as the German Federal Court of Justice was saying, as long as it's not about that, as long as you are meaningfully engaging with the system, the quality of this engagement should not play a role. It should definitely play a role when we do an inventive step assessment. Then we ask, what's the state of the art, what's the common general knowledge, whether the AI, I think it's very important, whether the AI or the data were part of the state of the art, that this allows us to filter out innovation which is not worthy of patent protection, because it is more likely to be repeated by competitors, so we want to reward that.
Another question, were you surprised when the Supreme Court went beyond saying, if you name an AI, you can't have a patent, saying, if there is an AI inventor, there's no patent?
Supreme Court, you mean in the UK?
Yeah, because I didn't think they had to go that far. But
no,
they
I
did.
didn't think so as well.
No.
Yes, it was a bit of a surprise.
Yeah.
Questions from the audience? Yes, sir.
Hi, I'm Jameson Bill. Shout loudly. This may be a question mainly for Virginia and Matt, but no, may have a view as well. You talked about sufficiency, but you didn't talk about plausibility. And is that because it doesn't create any problems, or is it because it just means the drafting of the patent has gone wrong, or do you have other thoughts on whether plausibility will come into play?
I didn't. Is this on? But default on. Thanks. I didn't talk about plausibility purely for lack of time. Not because it's not a potentially problem area. At the European Patent Office, the issue of plausibility is creeping into AI on the back of sufficiency, with similar issues arising potentially as have arisen in the life sciences for some time. But it's primarily at the moment looking at it's come up in the context of the timing at which you are able to submit evidence that your invention was in fact plausible. So there's this question of, is what you said in the patent application sufficiently plausible, or at least, I think the EPO put it, not implausible, such that if you want to produce evidence after the fact, you can do that. So in answer to your question, it's a hugely important topic, and I think we're going to see more of it, but remembering that the term plausibility has kind of been not invented, but like the law is sufficiency. It's coming in on the back of the sufficiency requirements and enabling disclosure.
Yeah,
Does that answer your question?
I would certainly echo that plausibility has been a moving target and has gone beyond sufficiency to other of the thresholds for getting a patent. Obviously, the interesting thing about generative AI is it's a plausibility machine. Yeah. Now, it may occasionally be completely wrong, but it sounds plausible all the time. And I don't know what effect that will have. And I did mention that it's all about correlation, not causation, although DeepMind and others are working on that. But I think if an AI spits out a target molecule and says, based on a literature search, this citation, it may make it plausible. I think if a modern scientist used AlphaFold and said, I think a protein of this shape will work, and I think it will have this shape because of AlphaFold, I suspect under current practice that would be acceptable as a basis for plausibility. What I don't know is to what extent we get to the point where people generally trust AI in fields of practice such that they find its outputs plausible for the test of avoiding armchair patents.
But not just the outputs. I mean, the issue of plausibility arises when you make assertions about an AI model that has been invented, and you believe you've adequately explained why what you've done is clever and innovative and non-obvious and will work in the area that you said it will work. But actually, there may be an inadequate explanation. No theoretical explanation, because you don't know exactly what the model's doing. You do know what data it was trained on, but you may not have all of that training data in your spec. So while I did say you don't need to put the training data in, if you are dealing with an area where you actually don't know precisely why the model's doing what it's doing so effectively, you might be well advised to put in at least your training data structures and some plausible explanation about that. Yeah.
So things can go wrong if you don't apply your mind to plausibility when drafting.
Oh, absolutely. No, absolutely. But again, I mean, Matt's right, it has extended beyond sufficiency, but I think from a practitioner point of view, it's all about the enabling disclosure with one eye closely focused on what your arguments are going to be for technical effects and inventive step, because that's where you're going to end up dealing with most of this, actually. Yeah.
I think that for that purpose, Matt was referring earlier to 1669-21, and one of the things that the EPO required there, when you seek to patent the actual AI, is a concrete, workable example.
Yes.
So it's enabling, but it goes into the plausibility. But you need to show that it works. At least one example.
Yeah.
We've got to go to Bruce.
Come on, Bruce.
Is that on? Done. Okay. My name is Bruce Dearling. I'm at Hepworth Brown for want of better description, on the attorney irresponsible for emotional perception. So firstly, I'd like to thank, I think this is probably the elephant in the room. So thank you, the panel, for your expert commentary on other aspects of AI this evening. So again, thank you from me. I took something from it. So returning to the subject, we said patent law, is it fit for the emotional AI age? Interestingly, I'll make two observations. Firstly, that in relation to the emotional perception case, there are rights granted in the US and Japan, not over in Europe, not over in the UK. Now, the European one, I can assure you, it's in prosecution, but there is not a chance that it will be heard. Even though today they appointed oral proceedings for that case, there is no chance that that case will be heard before the Supreme Court gets this. There is a strategy in place that I have which will delay that. So it's going to go to the Supreme Court, and I think that subject to me filing the paperwork on Friday and paying the fee. The questions I've got really are this. I'll make a statement first. In HTC versus Apple, Lord Justice Lewison said that the current Airtel test is singularly unhelpful. He also said that we concentrate on the gloss, looking to Airtel, and not the language of the statute. Now, we also have Lord Justice Arnold in the emotional perception case at the Court of Appeal. And if you look at the transcript, he was asking whether or not the court, he actually asked, you will find it, whether or not the courts have been getting it wrong for a long period of time. We sort of skirted over that, not making any observations. Now, the question that I really have for the panel is this. There are lots of issues which are will be raised before the Supreme Court on Airtel, on obviousness under Windsurf and Pozzoli, on alignment with the EPO under 137 of the Act in terms of any hardware and consistency of approach, so at the on the approach to exclusions, possibly also the convict issue as to whether that's the right approach. These are all up for grabs, or they will be discussed at least. So, with that in mind, what do each of you in the panel think about how do you think the Supreme Court should move in assessing the exclusions to patentability? And that might be a yes or no in relation to existing approaches in the UK or Europe. And also assessing inventive step. Are we right in the UK, or do you think the European approach is right? I would ask, justify your answer, but we simply don't have the time, and it's that question in itself is a seminar in its own right. So could I ask those questions? Do you think the approaches to assessing exclusion and assessing inventive step are correct as applied currently in the UK, or do you think there is a change required?
Could I ask you a question, Bruce, before coming to that? Which is, given that you've outlined what's going to be up in front of the Supreme Court potentially, is the core issue around whether or not it's treated as a mathematical method versus a computer program going to be on the agenda? Because that got sort of lost in the wash at the very early stage of argument.
I think the issue is that you've got to look at the patent statute. Section 1 says a program for a computer. You have to understand what a computer is. A computer is actually a technical term. So without understanding what a computer is in the first place, I think you have difficulty in understanding what a program for a computer would be. So that is something that is clearly going to be raised and we will look for clarification. And it's in some respect, I'm going to have a bit of a poke at the Patent Office now. It's disappointing. I'm really pleased that the Supreme Court have taken this issue up, because I think it's long overdue, and I think the profession has looked for clarification on this subject or these subjects for a long time. It's just a bit disappointing when I see that, when I saw that the arguments were, we have no skin in the game, we only want clarity, and yet they didn't support the application in the first place to the Supreme Court, which probably was justified. Anyway, that's another day. So yes, the issue of what a computer is and what a computer program is going to be core to the Supreme Court arguments.
Shall
Can I just-
Yeah.
I just want to go back to the. Is it on?
It's meant to be.
Okay.
Yep.
I want to go back to this plausibility question. Some of the discussion is always about the pattern bargain. I think the pattern bargain is a pretty naive view of this pattern system. It was very good once. The heroic inventor comes up with this idea, and secretly he can get a monopoly for 20 years, and then the patent can make the thing he made in his shed in the first place. That's not the real world. Take a farmer, which is the most extreme example. A bit of a hint of a twitch in a mouse or a frog. So well, that might be very good for something or other. Or stopping of a twitch. 20 years later, you've got a major pharmaceutical. That's not what he got his patent at the time at all. What the public get is not what he had at the beginning. He gets much, much more. So I think the patent bargain is a very dangerous tool in patent jurisprudence. It is used by naive Supreme Court judges around the world. The next thing I would say in this context is this question of plausibility, which James rightly raised, is rising very, very seriously here. If your AI machine says something works, molecules all fold up, and you can see that, as you suggested. Well, that's very good. Have you got a patentable invention? Well, I think you would have, subject to the question of whether it was done by a computer. Why? Because you are now going to invest in it to see whether it really works. And if the patent system is about investment, this is about investing in innovation. This is really important as far as pharma is concerned. It's less so in other fields, but it's still there. I think that's one of the real big policy questions. Let's have it another way. Supposing these machines turn out hundreds and hundreds of possible inventions. Is there any inventiveness in saying, well, I think that's the one that's really good. I don't quite know why. Something going on in the human mind is this is the one I'm going to take forward. So all these things are very, very complicated. And my worry is they'll all be dealt with at a very superficial level. I don't for a moment suppose the Supreme Court is going to decide what a computer is. And they won't even try. If even then you want to ask them, when he said, what kind of computer? The kind we have now or the kind they were talking about in 1972?
It's actually applicable. If you look at what a computer is, you can go back to 39 or 45 or 73 or 72 or today, and there is a definition which will fit.
Possibly.
So, and I totally agree on the investment points for sure. And then I will go first on emotional perception, so I can then leave Virginia to do the difficult stuff, because that's why you co-wrote the chapter with Tom Woodhouse is here as well, because I'm really not going to wade in on CII and the like.
Revised edition available.
Yes, indeed. Yeah, indeed. So my high level point on this is that you often get an accretion of tests in judgments around words, and then occasionally they get stripped back or refined or whatever it is. And one of the classic examples is obvious. But obvious is a word that has borne a dictionary definition since before anyone was born, or their grandparents, or from essentially for patents time immemorial. But I think the real problem that you face is that computer does not fall in that category. And if I try to strip back the accretions of Airtel or whatever it is, there is nothing in the word, and there is nothing in the preparatory papers that give me any guidance at all as to what the policy was. And so I really don't know how the Supreme Court should deal with that. They have to make a decision. And I think if I was a betting person, I think they will struggle to disagree with the Court of Appeal's definition of computer for want of anything better. And then I think the rest of the judgment arguably flows from that. I mean, I'm sure you disagree, but that's my concern. But it's not a detailed one, obviously.
Yeah.
Virginia, you're going to...
Good evening, distinguished panel. Thank you for the delivery of this lecture. I guess I have rather a question from the fantasy domain. Do you think that electronic person could ever become inventor? So what is the plausibility that, for example, UK statutory provision would include not only natural, but, for example, electronic person? Is it not even in the nearest future?
You mean as a legal
Yes,
person with
yes,
legal
as a
rights?
legal concept.
I think the European Parliament had to go at this. 2016, their Science and Tech Committee made a recommendation to the Commission to consider the establishment of a status of an electronic personhood, which, luckily, in my view, the Commission just ignored. I think that it's so. Without being cynical, I think it's a bunch of very well-intending people, but when you read the kind of consideration they took into account, to me at least, it seems that they tended, or they mix science with science fiction.
Well, I think we can say the French, I don't know what mechanism it was, but there was a move to write into their constitution that would never happen, but it was abandoned. So we've had, it's been ignored repeatedly. But we don't have to be in the realms of science fiction at all. We don't have to say that a computer needs to be conscious or have some threshold. We have artificial legal entities anyway. We've got companies, and they serve a legal purpose. So there's absolutely no reason legally now, without delving into science fiction, why you couldn't do it.
How would you raise the veil, under which circumstances? Because the whole idea is that there is no veil, there is no person behind. There's something which is autonomous.
Okay, got it. Yeah, fine.
Right?
Okay, so maybe it's the owner or the developer or whatever it is. But my broader point is, why bother? What purpose is it serving? And we've always had, in the era of patents, well, I may get my timing wrong, I guess patents predate companies as legal entities, Elizabeth I and all.
No, because they were
Royal charters.
Royal charters.
Okay. The universities of Oxford and Cambridge predated the patent system. But we've had companies alongside our modern patent law, and they've never been allowed to be inventors. So why introduce another artificial entity? Julian?
Do you want me to comment?
Oh, sorry.
Yeah.
While the microphone's being moved around, why don't you go ahead?
No.
Okay.
I'll let the questions to the audience.
This is an observation. The thing about companies is they have boards, and they can make decisions, and that's why they have legal structures and they're legal persons. How would you get the artificial organ, that is the electronic inventor, to make decisions? Or would you
bad
incorporate
news.
them?
AI is making decisions about you all the time.
Within the legal context is what I mean, in the same way that the company does.
Yeah, but again, you had to have the fiction of the legal entity of a company for it to be allowed under law to enter contracts. It's a legal mechanism. You could do it for a machine if you wanted. The DAO, the Distributed Autonomous Organization, is an attempt by grassroots to do exactly that. Come on, we've got to talk a bit more about emotional perception, please.
Do you want me to comment on emotional perception?
Actually, one thing I was going to say is that actually it's about the definitions of computer. You will find that if you look at again, Lord Justice Lewis, and I think it was also Lord Justice Nichols, they define a computer as in a different way from the current Court of Appeal. So I'm not sure that that's what you're saying is...
Well, no.
I mean,
rival definitions are available, but there's no way to figure out what
at the moment, we'll see what the Supreme Court decided, and that's the important thing. Sorry. Virginia.
Just my take on emotional perception, for what it's worth, is this issue over the mathematical model point, because at the moment we've got a situation where the European Patent Office, which is going to grant rights which are effective in the UK, are looking at this they're looking at AI models as mathematical models, and all the law around mathematical models is being imported into the treatment of AI innovation at the EPO. Whereas at the UK IPO, the way this case has gone, it's looking at it from the perspective, as you rightly mentioned, as a programme for a computer. And I don't know whether or not the Supreme Court's going to take up this point about whether or not it's a mathematical model is a point worth deciding, and if so, which side they're going to come down on. So my take on emotional perception is it's come along a journey where we now have a situation where the current Court of Appeal has said that weights in a model are a computer program, which doesn't address the mathematical model point, and it doesn't really firmly address the computer point. So I think the Supreme Court have got a lot to chew on. Sorry, that's all I wanted to say. Yeah, I don't have any particular magic insight into it.
And if I could come in as well, so being government, some strictures on what I can say. I'm not going to sit here and say no comment though. I think if the Supreme Court decides a different way to the Court of Appeal, there's a kind of immediate, potentially practical implication in that UK patents granted to the EPO route, where it might be you might get a different result if you went through the UK IPO, and that might lead to some ballroom shopping, which probably is not a good thing for the UK patent system as a whole, both IPO and EPO routes. So,
will the office intervene in the Supreme Court? It did so very well in Skykick.
I think I probably have to go back to.
You've got to be thinking about it. Yeah, I'm not. But you've got to think about it quite a lot.
Yeah.
I think we're out of time. So do
we're out of time. It's drinkies.
do the panelists have any more final comments, or will just remains for me then to thank each of the panelists for who spoke so well and so eloquently today, and to thank Sir Robin and the Institution for Brand and Innovation Law, and to thank you, the audience, for sitting through this very informative panel this evening, and also to our virtual audience as well for participating remotely. So thank you very much. Thank you.